And the phone, nobody answers. What are they going to do? They're going to go to the next one on the list. It's important that the call be answered. Now, you might say, well, I can handle these calls, and I'm a lawyer, but my secretary, she hasn't, or he hasn't been with me long enough to really understand this very well. Well, maybe you ought to have a little computer program on your desk and on your secretary's desk, or whoever answers the phone, and they can take down some basic information, such as what's the person's name, what's their address, what's their phone, what kind of problem are they having, maybe a security deposit, maybe I'm going to be in a eviction court tomorrow or Wednesday, I don't know what to do. Let me have your number, because the lawyer will call you today, and we'll set up an appointment, and if it's that swift, we'll set it up quickly. Next thing would be an appointment. That person sets up an appointment. Obviously needs access to somebody's calendar to be able to set up an appointment. The appointment comes in that questionnaire, and I'm talking about a lot of automation that you may think, unless you're automated now, you may think is rocket science and well beyond your means. Not true. Separate seminar, separate discussion about technology issues. But a lot of law firms are starting to do these kind of things. The person comes in, they're interviewed, many more questions are asked and answered, and then a lawyer makes an assessment. Now, it may be that if it's an eviction, you just can't or don't want to handle it. It may be that the landlord, is a distant cousin. You don't want that kind of a problem. There may be another conflict or reason you don't want to handle it. But the lawyer can make an informed decision, and again, under ideal circumstances. And part of what we're going to put up on the web for you is some basic forms, some forms of complaints for security deposit, some forms of appearance and jury demand and transfer order, a form of affirmative defense, and some counterclaims. And a response, and this will tickle the fancy of some people we haven't done this with yet, but an extensive response to a motion for use and occupancy. Because we want to do that and perhaps get judges to think a little bit more about the concept of use and occupancy, which another speaker will deal on. So all of these things are available or will be available. Those of you who are on any listservs with any of the bar associations should find them very, very helpful. The Illinois Bar has a terrific listserv. Chicago Bar recently got into the listserv aspect. We're talking now about trying to start a subcommittee at the Chicago Bar Association as part of the Consumer Law Committee for Landlord Tenant Law, and try to get monthly meetings together, landlords and tenants, because I respect the fact that landlords have some problems as well. And there's new problems surfacing all the time, such as how does the sheriff evict or not evict people anymore, or what is the effect of a new decision that just came down within the last 30 days that the judge can't evict a tenant who doesn't pay the court-ordered use and occupancy if they don't pay it and they can't afford to pay it. That is a revolutionary decision. It may be appealed, but there's lots of issues, and there are things that can help landlords and should be there, as well as a lot of things helping tenants. Resources. How do you find out anything about the situation besides interviewing your client? And you'll find this in the handout materials. How do you investigate the case? Well, you can go to the clerk of the circuit court. One thing we've learned to do, learned it the hard way, because I've run into, over the last 20 years, a couple of professional tenants by saying they know the system better than lawyers know. And when you do a search on their name, you may find that they've been to the eviction court 6 times in the last 10 years and probably haven't paid more than 3 months of rent over that period of time, because they're clever and they're smart. I don't want to represent those kind of people. I want to represent people who really need help. Not a pro who outfoxes me and doesn't tell me their background and their goal. And then part of their goal is not to pay me ever. If I end up owing the landlord so much money, it doesn't matter if I have 52 counterclaims. My 52 counterclaims will not exceed the amount that's owed the landlord, and that's not good when you're looking for fees. You can get basic information about the building. There's a place on the internet, it's in my handout, newschicago.org, that you can put in the address and you'll get a picture of the building, you'll get the number of units. Sometimes we find people in basement apartments, and it's a 2-flat building, but they're in the basement apartment. It's zoned only for 2 units Interesting defense, like it's an illegal lease because it wasn't zoned properly. You can get that online. Compare that before technology became so important to us. How would you find that out? You'd probably go over to the recorder's office and spend 3.5 weeks trying to find the right book that probably is being written by scribes over there in the old system, and you never find this out. Also, with New Chicago, you get the PIN. Part of what you have to think about is this landlord collectible? Well, another reason to do a search, if you see some of our infamous, and I won't mention you all, but infamous landlord lawyers, if you see Dan Starr, for example, or Herb Goldman, or some of the other regular landlord lawyers representing a landlord, you can bet they got money. You can bet your bottom dollar. Because they won't represent them unless they did. Okay. Then you look on the recorder's office, and you may see that Paul Bernstein, if I own the building, which I don't, I've owned it for 22 years, and the mortgage I had on the building is paid off, and I'm in an up-and-coming neighborhood, and I celebrate when I see them. It's like Pavlov's dogs. I get very excited when I see that the landlord has a big equity in the property and could withstand a nice judgment. The building code. I can't tell you how long we searched for a copy of the City of Chicago building code. That there's a service that publishes it, and it's on the internet, but you got to subscribe, and it ain't cheap. Or you go to the Law Bulletin. Hope there's nobody here from the Law Bulletin. We'll charge you a lot of money to subscribe to the hard copy of that product. Well, there's a site in the handout. This one thing may make this whole situation worthwhile. Where on the City of Chicago website, there you got to find it. It's actually in the legal department part of the City of Chicago website, where you could get access to that same building code for no money at all. And it's terribly helpful. The judge is asking you, well, you got to be more precise. You say that the windows don't close and don't open. Or if you say it's a violation of the building code, what section of the building code does that violate? And I must tell you, I don't think there's any judges here from the eviction courts. They have a tough problem too. The problem is there's too few courtrooms and too few judges. And the average trial is less than 2 minutes for a reason that people are not represented. Because they got to move their calendars. All the judges want to move their calendars. Suppose every time a tenant came into each of the separate parts of eviction courts, of which there are several, but not enough, that they really listened and said, well, maybe we ought to set this down for trial. It sounds like there's some issues here. They would never evict anybody, and they're free to tell you that. They're free to tell you that. One judge, again, don't unmentioned by name, I happen to be, once in a while, if I think some of my fellow tenant advocates are being a little bit too zealous and killing the goose that laid the golden egg, which is the Chicago residential landlord tenant owners, that I'll represent typically just one or two where they invested in a home and they didn't know there was an ordinance, so they got caught. I'm up in court filing an appearance happily as co-counsel for the landlord. And I won't mention the lawyer on the other side, but they filed a motion for summary judgment based upon the fact that the tenant had a carbonized checkbook, got a 5-day notice, paid the rents as the tenant in the 5 days, had a copy of the check in their checkbook. But the landlord, looking at it from a tenant's perspective, never cashed the check. Clever person. And the position of the tenant's attorney was that the client, the tenant, had paid the rent within the 5 days, and the fact that the landlord held on to it, which the landlord didn't admit, denied it, should not prejudice, the tenant, and the eviction should be dismissed. And the judge threatened to sanction that lawyer because he put this in a motion for summary judgment. And in effect said, how dare you assume that the landlord held the check? Maybe it's just as likely that the tenant never sent the check. The fact that they have a carbon copy of the check, what does that mean? And then finally said, and this was something everybody heard, and counsel, if I believed every tenant in this courtroom who came up and said, I never got a 5-day notice, you know what happened? Sure. Or I got the 5-day notice, but I paid the rent within the 5 days, but he wouldn't or she wouldn't take it, and here's my check to prove it. He said, if I took that position, we would never evict anybody. Imagine that. Aren't you entitled